We're live, Mr. Wade.
Good night, good night to our Belizean public, both at home and abroad. Welcome to our 278th edition of our Belizean Affairs on a blessed Wednesday night, April 2025. And who we have with us here tonight? Mr. Gregory Morrison. He I at one point I thought he had deserted us, right? But
Not quite, not quite.
I take that back, right? But he's always welcome, and welcome, Mr. Morrison. Welcome with
Good
us here
evening.
tonight.
Thank you very much.
And of course, we have no other than Mr. Leonard Brackett, and we will be joined shortly by Gregory Brackett. He's in the background queuing up, and as I'm the chairman for tonight's show, but there are some issues that want need to hear that need to be discussed, and so that the public could know exactly what's going on in real time, not what the other news talking about. I mean, seemed like it was a one-sided story in my view, but here on this show, we'll prove that the story has a two side. So after we go through the formalities and Gregory join us, I will pass the show over to Gregory. Um, Leonard, you
Yes,
want
sir.
to
278.
start us off with a prayer,
Yes, sir, I will.
my brother? Thank you.
Let me just save that for right now. And then I could come back and fix that afterwards. Thank you, Mr. Wade, for the privilege to participate with you tonight, sir. And as the chairman, I know you're going to do us a good thing tonight. And I know that with the help of Mr. Morrison as well, and with what Gregory is loading up, hopefully we present a fair enough program that our listeners will derive some public benefit from. Again, thank you very much for the privilege to participate with you guys, and again, welcome, Mr. Morrison.
Mr. Morrison.
Thank you for gracing us, sir. And I'll just bow my head in and say a short prayer. I don't think I'll make this one too long because we're running a little late too. Divine loving Father, we thank thee for this privilege to come before thy presence once more. We pray that thou mayest continue to guide us, protect us, give us wisdom, knowledge, understanding, endurance, courage, strength, perseverance, and the fortitude to be able to speak truth to power if and when needed. We pray that thou mayest continue to bless our family members. Thou knowest them by name and number, each and every one of them. Thou knowest our hearts, our desires, even our most secret thoughts. Please bless those people who are in harm's way, in war zones and tornadoes and all kind of other disasters, Lord Father, fires and whatever else. We pray that thou mayest be merciful unto those who need food, clothes, and shelter. For we ask these mercies in Jesus' name. Amen. Back to you, Mr. Wade.
Thank you, Leonard, for that warm prayer. I'll do a reading from Proverbs 1 to 10, and it chapter 11, 1 to 10, and it reads: A false balance is an abomination to the Lord,
Amen.
but a just weight is his delight. When pride comes, then comes disgrace, but with the humble is wisdom.
Amen.
The integrity of the upright guides them, but the crookedness of the treacherous destroys them. Riches do not profit in the day of wrath, but righteous delivers from death.
Amen.
The righteousness of the blameless keeps his ways straight, but the wicked falls by his own wickedness. The righteousness of the upright delivers them, but the treacherous are taken captive by their lust. When the wicked dies, his hope will perish, but the expectation of wrath, wealth perishes too. But righteous is delivered from trouble, and the wicked walks into it instead. With his mouth and the godless man would destroy his neighbor. But by knowledge the righteous are delivered. When it goes well with the righteous, the city rejoices. And when the wicked perish, there are shouts of gladness. That's my reading from Proverbs chapter 11, 1 to 10. Uh, you know, there's a lot going on in our country, especially lately we have the redistricting case went to court on Monday, and there are lots of things happen. I did not speak to the media. Our attorney did, um, but tonight um, we want to with Mr. Morrison and Leonard and Greg, since they are not part of the case, but at least they could talk a little about it and educate the public of what's really going on and what had transpired. Because some media houses, it seems like it's a one-sided story for whatever reason, you know. So I would like to give Mr. Morrison a little chance to say if he have see if he have something to say. Otherwise, anything that he want to talk about a little bit until Greg shows up, so he could cue something up on show and tell. Mr. Morrison, I pass it over to you, sir.
Um, Mr. Wade, Mr. Chairman,
Yes, sir.
after Mr. Morrison does his introduction and his little short speech, if Greg hasn't come back by then, at least
I'll pass it over to you.
I'd like to be able to make a couple of statements in regards to
Sure.
some technical words that will come up in our discussion that people should be appraised of in terms of what they really mean or how it affects what is it that we are talking about, or the rules, or the case laws, or the judges. They are just different things. But I don't want to belabor it too much. So I
Yeah,
just
thank you. Sure,
yield back,
Leonard,
Mr.
not a
Chairman.
problem. Let Mr. Gregory have the floor, please. Go ahead, Mr. Gregory.
Oh, his mic is
Oh, your
off.
mic is off to Mr. Morrison.
I just unmuted. Sorry about that, Mr. Morrison. Oh, he went mute again.
Let me unmute it.
Okay,
Okay,
no, it's
I
all
got
right.
it.
Uh-huh.
Thanks for the help. Good evening, gentlemen, and good evening to our wonderful audience, which is wide and large and distributed all across this planet Earth. I heard from my cousin that lives in England. Actually, she's British, and she tells me she listens in sometimes.
Great,
We have
great,
people. We have people from
great.
Australia. We have people from all over, all over. So
Yeah.
Oh, yes.
So,
God bless. Thank him.
I- yeah, I just wanted to say that indeed there's a lot going on. We just had the recent U.S. election. We had the Belize election. We had the situation that we were talking about briefly there. The the court case regarding the redistricting and trying to understand where that will fall. Um, I don't know too much about it, and so I'm here to learn from you guys that's actively on the ground pursuing it and trying to see what this will stand up and how this will influence the jurisprudence and the laws and constitution of our country as we move forward. Because I think probably what has happened with the election coming and going, the issue might be foregone in terms of where we are with the election. And whether a court would rule that that's unconstitutional, I think probably not in the way it's currently constructed. But it does put a lot of concern. Am I getting a better echo? Is it coming through to you guys still?
Uh,
uh,
Okay.
not right now. I don't.
Okay,
Yeah.
that's fine. I hear a little bit of an echo on mine. If it's just on mine, then that's fine. Um, So it is a little concerning, the way the whole thing has been overpassed by the government, the way they trumped it up with the chief justice and them in ruling so that they could move forward without the election, without putting a stop to it and requiring that the laws and the constitution of the country be followed. But as we move forward, we need to look at systems, governmental systems. It seems that there have been and there continue to be a breakdown of this structure, and even the system we had once relied on so much seem to have cracks and breaks in it. And so we just have to wonder
Mm-hmm.
where things will be. You know, the nature of human being and human behavior is in the long evolution and arc is that it will self-correct to some sensible point and balance. But what we forego in that period and the suffering and the challenges, and it doesn't just self-correct, people needs to step in and make that correction. So when I said self-correct, I don't mean it just does it on its own. I meant that people become conscious of the flaws and the faults that they're encountering and the danger it places us all in, and they start making those adjustments to make corrections to the systems. And I'm hoping that that will happen. We are seeing it in on a wide scale. We're seeing it on an international level, and it's troubling, and it creates issues for all of us to be concerned, especially small states like Belize and other countries where the breakdown and the safeguard are not there to make the adjustment quickly. And so for that, I'll just pass it back to you guys. But those are my observation that I'm faced with and the challenge I see going forward.
Thank you, Mr. Morrison, for your observation and your input. Um, Leonard, you want to go first, or before I pass it
Yes,
over
sir.
to Greg? We'll
Uh-huh.
show over to Greg.
Yes. Um, Good night, Belizeans at home and abroad. Thank you very much for tuning in tonight. I hope that you'll be patient with us. We're going to be touching some very serious and critical issues or matters that relates to the Constitution of Belize as currently is, because there are times when people refer to the Constitution of Belize, even our attorney generals and the prime minister and other people, as if it were the new constitution that they are trying to put in place. When in fact that's not the case. Belize can only have one constitution at a time. And so I beg your indulgence and your patience. We will be discussing these matters seriously tonight as regards to a particular case that was just ruled upon. Well, the ruling is reserved so far, so it's not public yet. But the hearing that was had on the 7th of this month, last Monday, and we need to address these matters and to afford these judges and these lawyers the opportunity to recognize that we, the Belizeans, are not as stupid and fool as they think that we are, and that we are looking over their shoulders. We know enough, many of us, we know enough to be able to point out their errors, omissions, and oversights, and sometimes deliberately uh, um, confiscations. But I won't try to get ahead of the program. The chairman for the program tonight, Mr. Wade, has deferred chairmanship to our learned and senior panelist and individual, Mr. Greg Brackett, who helps us with the show and tell part of our program. And he has some stuff lined up. But before he does that, I just want to beg your indulgence to please pay attention to what we are saying. We don't expect to turn you into lawyers overnight or legal trained minds overnight. But if you bear with us, you'll be better off for having done so. There are a couple of, well, not a couple, there's going to be quite a few, but I want to at least clarify up front and explain what some of these terms that we're going to use mean, so that when you hear them being used and the context in which they are being used, you'll be able to understand a little bit more about what they are talking about and how it's being referred to. For example, estoppel. Estoppel is a term, one word, that in legal jargon among the lawyers and case management people and people who deal with legal issues, they refer to this term estoppel, which means that it's like a block or a barrier that blocks something or someone that stops you from being able to make forward progress. In other words, if you use the term or the word stop in I was going to say in Belize, in Belize Creole, in English, right? If you use the term stop, something has to stop you in order for you to stop, either by your own kinetic energies or some other something that takes over your ability to move forward, backward, sideways, or in some form or another. Basically, you're stopped, you're blocked. So that's what estoppel in the legal sense implies. You are blocked from something, you cannot go forward, right? And then you have another term, well, not a term, but another theory. Uh, Estoppel is a theory, a one-word theory. Um, res, res judicata is a two-word theory. What it means when it says res judicata, the term or word rest, or to bring to rest, or to put to rest, or forced to rest, and in addition to the word judicata, which means to adjudge, means that if something is adjudged, then you don't have an option. In a legal sense, when you're dealing with legal matters, if something is previously adjudged, you don't have the option because that matter is rest. It's put to rest by judgment, by basis of a judgment passed by a judge. It's a legal term to clarify or to explain that, for example, in the case that the judge has currently held over for his ruling, at one part when this case by Mr. Roody was brought, there had been another case prior to his case, and that case had asked the court to look into the issue of the violation of the Constitution by the government as regards to Section 90 and others, such as Section 6 and others. What had happened is that because the first litigants who brought the case had asked the judge to force the government or to make a ruling as per Section 20, which the judge have authority over by virtue of the Section 95 powers that is granted under our Constitution to the third branch of government, which is our legal system. The plaintiffs were asking the judge to look into the matter as they had alleged in quite a few different statements of allegations, right? That the government was contravening the Constitution and was willfully not complying with constitutional mandates and precepts or principles. And they were doing so disregarding the mandate that is placed on their head as government to exercise certain rules, regulations, practices, and laws to afford the populace of the country their rights. In other words, the Constitution dictates what is right, what is legal, what is constitutional. The judges have the power vested in them to make declarations and or to point out where a law is being violated, where a constitutional precept or principle or section is being violated, and therefore the claimants went to the judge to ask the judge to do his job, basically. But for all intents and purposes, I'm cutting the whole of that 40-odd pages that the judge gave us his rendition to the judgment. I'm cutting it short, right? I can't read or deal with 40 pages right now in this particular program with everything else that's going to come along with it. So I'm cutting parts of it short, but I'm giving you the essence of what had transpired before and why is it that we are where we are today. The previous judge, in her 41 pages ruling, had stipulated that because the plaintiff had entered into a side agreement with the government at or under the powers vested in the judge, that the judge granted them that opportunity to enter into that side agreement, when in fact the judge at that point, instead of granting that agreement that the government was trying to use to get out of having a ruling against them, the judge should have actually ruled, because at that point the judge had already heard enough of the case that was submitted and articulated, whereby the government side was agreeing that they were in contravention of the Constitution, they were violating the Constitution, and so they wanted to play a fast and loose game on the court to bamboozle the court as well as the plaintiffs by asking them to enter into this side agreement where the judge, where the court is going, not the court, where the government is going to agree to go ahead and make redress, deal with these matters. And of course, that's all the plaintiff wanted. The plaintiff wasn't looking for no money or damages and so on from the government. They were trying to force the government to do what's right. So the government did not want the ruling to come down against them, so they decided to plead that they were guilty of the crime and to ask for this side deal to allow them to go back, spend the time, and make the corrections. And the plaintiff, in good faith, entered into that agreement, not realizing that they were being suckered into a situation where that agreement would have been classified later on by the judge as a tumbling agreement. When these people went back to tell the judge that the government did some semi-dividend, did a little sleight of hand, but they never complied or met compliance. And therefore now the plaintiff were asking the judge to make the final ruling and let the government have to be forced under the color of law to do what they said they wanted to do and correct, but that they were not correcting and doing it, dutifully. Instead, the judge ruled on this ideal and forgot or left alone the original complaint for the government to continue violating the Constitution. From what I understand of jurisprudence and the temperament of judges and the rule of law, judges are supposed to rule according to law. And a constitutional matter that it wasn't just a basic civic issue or a basic tort law issue. It was a constitutional issue. And somewhere along the line, I'm of the impression that this judge, the question that was brought to the judge may have been a bigger issue for that judge to handle and they were capable of. It shouldn't have to be, because most judges, in fact, most law students would be able to recognize that if the Constitution says one thing, that is the basis of the law, which I think, who was it that Mr. Morrison earlier said in his comments, that we don't seem to be having the certainty of law anymore. We have always known our society to be a society of law. And under the system that we used to expect, we had an expectation of lawfulness in our society. No one would expect that our Attorney General or Prime Minister or any other minister or any other parts of our governance, in terms of even the judiciary and any members of the judiciary, would put our Constitution on its head or throw it down the drain. Because under Section 2 of the Constitution, it says the Constitution under Section 2, subsection 1 says, if the Constitution of Belize is the supreme law of the land. We don't have a supreme legislator. We have a Supreme Court. And we have a supreme law of the land. And if any other law is inconsistent with that supreme law of the land, that other law is then, to the extent of its inconsistency, null and void. But here we have citizens of our country have to go and take up these matters in court against the government, for the government to use the treasury to try and beat them down and get a powerful law firm who submit bogus information to the court and have the court turn around and try to rule on the bogus information that they present, rather than for them to answer the question that the plaintiff brought to the court. So many of us who know what's going on and what took place and is still going on are aggrieved. And the Prime Minister is talking crap about well, in the next 2 years, maybe he might get it done, as if he hadn't said that more than a year before he got elected in the last term. So he got elected, spent a term, didn't complete it, and is in a second term now talking about, well, he need another couple of years or more. When we have shown on this particular show or platform that the matter can be dealt with in less than 6 hours. We showed them how it could be done in 3 hours. We said, okay, give them 6 hours, 1 day, or give them 3 days, or give them 6 days, or give them 6 weeks, or give them 6 months. And they could have still got the damn thing done if they really had the heart and the willingness and was compliant according to the demands of our constitution to get the issue completed. Now they want to say, okay, well, they want to throw out Mr. Wade's case because the matter was adjudged, there was a ruling, and therefore Mr. Wade case being on the same issue is a stopped or a stoppel. Or because it was adjudged, it's res judicata, it's laid to rest by judicial ruling. Those do not exist. The matter was never dealt with effectively. What the judge did and said that she did or ruled on was this deal that the previous people entered into. That does not squash the original constitutional violation that the government had already acknowledged doing, and it had asked for time to do it then, and is now apparently asking for additional time to go get it done. They're playing the same game back and forward over and over. But I'm overdoing it. Took more
Yes,
time
thank
than
you,
I anticipated.
Leonard.
Thank you, Mr.
Thank you,
Chairman, for the
Leonard. I
opportunity.
pass it over to Greg for he has something lined up to show and tell also.
Good night to you, gentlemen. Good night to the people at home and abroad.
Good night.
I'm sitting down here listening to my cousin beat up on himself, trying to explain the legal matter of what is going on. But there is few of us who have dealt with civil law and knows what civil litigation is. I want to go back in time to 2019 when this case was first presented by Mr. Parker Smith. At that time, the Chief Justice had made a claim, and I will go to the tape so the people at home can hear what Miss Arana had to say at that time. I will go down the line to clarify everything that the present government is trying to do, and I will make it make sense for you, the people at home and abroad, so that when you leave from here tonight, you will see the implication. This is what was said by Miss Arana.
Justice Michelle Arana denied the government of Belize's application to have the Belize Peace Movement's redistricting case struck out. The case was taken before the courts in 2019, and since then, Acting Chief Justice Arana has ruled twice in favor of the Belize Peace Movement, the BPM. The latest one allowing the redistricting case to proceed. Today, the BPM held a press conference with their lawyers and all 10 claimants to give an update on the case. Attorneys at law, authors.
Gentlemen and people at home and abroad, Chief Justice Ms. Arana refused to struck out the redistricting case because the underlying had merits.
Greg?
Go ahead, sir.
A statement. Before Chief Justice Arana had taken up that case, which was assigned to her after the previous Chief Justice, I think was it Benjamin or County? I don't remember exactly which one it was. But one of them had said that the
Chief Justice Benjamin.
Benjamin, okay, that the case had merits and that the case should be given a full hearing. So, but he had also ruled against the government in the referendum issues, and therefore the government did not renew his contract. He had to depart, and that matter was taken up by the temporary Supreme Judge Chief
Let
Justice
me,
Arana.
Mr. Brackett, stay focused so I don't lose the people at home and
Go ahead.
abroad.
Go ahead.
The case was first heard by the Chief Justice, Mr. Kante, who ruled it had merits. The case was heard by Mr. Rana, who also believed that the case had merits. Okay, now I want to go to a tape to listen to what was said at that time.
Boundaries Commission is the oversight body that steers or advises and takes the concerns to the Election Boundaries Department for them to act. And in this respect, they have the responsibility to look at the voting the distribution of the voters around the country to determine whether or not these constituencies are equal. Now, there's been a re-registration exercise that was ongoing. And that was one of the other things that was mentioned in the injunction hearing, that because there was re-registration going, we would not have a very accurate view of what the distribution will be at the end, because the re-registration exercise was still at a stage where it was unsure what the final outcome would look like. We know that now, and we have put in an addendum to our pleadings to show what the breakdown and distribution of the voting population is like now in 2022, as of this date in 2022. Nothing has changed in the grand scheme of things. Fort George is still the smallest division. Stan Creek West is still the largest division by more than 10 times the size of Fort George.
Now, people at home and abroad, I have taken you back to what was going on from since 2019, and I will bring you to present. Now, most people living abroad knows what happens when you go to court. If
Can
you
I
have
ask you?
a
Can I
case,
stop you just a little bit there, Greg? Do you have anything on 2019 and 2020 just after the election? What was said in the terms of redistricting
Mr.
by?
Chairman,
I don't know
I
if
will,
I just
I,
asked you.
I will clarify everything to present
Thank you.
so that the
Thank
people
you.
can see it and hear it as we do
Thank
on
you.
Belizean affairs.
Thank you very much.
As I was saying, in criminal law, most people know what double jeopardy is and how that happens. Here we have civil law, and we have the government attorneys talking about res judicata or estoppel. I want to say this right here tonight. Res judicata and estoppel does not exist in this case, and any other electorate can go and file against the government again for violation of their rights for not doing the redistricting. And I will prove it, as I always do. Okay? Now, for the merit, I want you guys and people at home and abroad to listen carefully to this tape, because I had a conversation with my cousin last night, and I keep expressing to him, when we talk about case and laws and constitution, it is based on merit. It is based on merit. So let's listen to the tape.
Importance.
Importantly, the issue which has persuaded me to rule in favor of the claimants/respondents is the gravity, complexity, and importance of the nature of this claim. This court is ever mindful and respectful of the doctrine of the separation of powers so ably articulated by Mrs. Tucker in her arguments on behalf of the defendants applicants on this application. However, as Mr. Saldiva has submitted on behalf of the claimants, quite correctly in my view, this claim goes to the heart of our democracy by raising valid questions for this court's consideration. Has there been compliance by the Elections and Boundaries Commission with the one man, one vote principle as mandated by the Constitution of Belize as this nation's highest law? Is there malapportionment of electoral constituencies as is there a proposal laid before Parliament as expressly required by the mandatory language used in Section 90 of the Constitution to remedy that malapportionment? Striking out is a draconian measure of last resort, and to my mind, this claim is ill-suited to be struck out on procedural irregularities. It is a claim of fundamental constitutional importance, which calls for the court to fulfill its role as a vigilant and fearless watchdog of the constitutional rights of the citizenry. I therefore refuse to grant this application to strike out claim.
Attorneys?
Section 95.
Gentlemen and
Go ahead,
people
Greg.
at home and abroad, we know what happened in the case, why the case was dismissed. We all know about the agreement, and we all know that the government had said they were in compliance because they were doing what was necessary. Now we all know that that is a fib. They were not in compliance, and they could not be in compliance because they, before the general election was called, they knew that it wouldn't pass. They knew what was happening. And exactly what happened in the Enriquez case with the attorney, that they knew the court, by filing an injunction, could not step in the separation of powers to block an election. The government knew if they used compliance, they would get through the court. Procedural error. So they continue to have an illegal election and the dismissal. Then, after they had the illegal election, they had this case to finish. Now you hear them coming talking about res judicata and estoppel. I will tell you why it cannot pass. But first,
Mr. Chairman?
let's play the tape.
Mr. Chairman?
Oh, hold on, Leonard. Let Greg
One
finish
statement,
up then.
One statement.
Go ahead, sir.
They had to have a res judicata before they can have an estoppel. And none of those existed, as you said earlier, in the previous case. So there's no reason for them to try and kick out Mr. Wade's case under those conditions. It doesn't exist, as you said. I yield back.
Okay, let me say this to you, the people at home and abroad, right? By dismissing a cause does not give that dismissal a final judgment if it was not on the merits. So when that dismissal had nothing to do with the alignment of the Constitution, you can refile and refile as you wanted. Okay? Anybody still can go refile. Because you know what they did? Exactly what they were saying Mr. Ram Logan did. They knew they were going to have an illegal election because they couldn't get it done. So they went to the court and they had it passed through, yes, we are in compliance.
They lied to
when
the
they
court.
knew they were not in compliance.
They
And I will
refused to
tell
do.
you why. Because I always say these people tell on themselves. Now let's go to the tape that was played. And I want people, you at home and abroad, to listen. It's important to hear what is being said, especially at the end.
This morning, Justice Tawanda Hondora heard arguments in a case brought by 7 people against the Attorney General and the Elections and Boundaries Commission. The claimants are asking the court to declare that the current electoral boundaries violate the Constitution of Belize. Senior Counsel Hubert Ellerington represented the claimants, stepping in for attorney Sharon Pitts.
We are saying to the Elections and Boundaries Commission, you have a duty not to hold any old election. Your election must be constitutional. And we are going to bring you to the court to compel you to do that if you don't know what your duty is. And if the Attorney General of Belize does not know what he should advise you, we are going to bring you, despite his defects and shortcomings. He is the one that should have been fighting for us. You see, we were depending on the Attorney General to fight for us.
Meanwhile, the defendants' attorneys, Senior Counsel Eamon Courtney and Hector Guerra, have asked the court to prevent all 7 claimants from pursuing the case, arguing that it should be dismissed under the principle of res judicata. It prevents the case from being tried again once it had been decided by a competent court. The defendants argue that 6 of the 7 claimants, except for Roody Wade, were claimants in case 55 of 2019. That case ended with the widely reported redistricting consent order.
We presented arguments today that focused on 2 points. The first is that we said the matter was res judicata, meaning there is a previous case, the Parker Smith case, if you recall, from back in 2019, which addressed similar issues and in which 6 of the 7 claimants today were also involved. And so we advanced arguments to say that this is abusive. This matter has already been decided by the court, and in fact a consent order was issued by the court that was agreed to by all the parties and that addressed the very same arguments that are being advanced by the claimants. That is malapportionment.
The defendants also argued that although Roody Wade wasn't a claimant in the 2019 case, he shares a mutual interest and relationship with the original claimants.
The simple fact that we're trying to advance, the simple argument that we're trying to make is that Mr. Wade shares a similar interest along with the other claimants. He was aware of the previous claim by virtue of reading the decision of Justice Nabe. He has advanced evidence by way of affidavits in these proceedings, and really the reliefs that were sought in the Parker Smith claim and in this claim all surround the issue of electoral divisions.
The 7 claimants argue that neither the 2019 nor the 2023 case, where they sought to enforce the consent order, resulted in a final decision on whether the current electoral boundaries are constitutional.
The Constitution gives certain powers to the National Assembly. The Constitution gives certain powers to the courts. The Constitution gives certain powers to the cabinet, correct? But it also, very importantly, gives a specific constitutional duty to the Election and Boundaries Commission. Thou shalt hold general elections every 5 years at the most, which are constitutional. The issue as to whether the schedule to the ROPA, Representation of the People's Act, ROPA, Representation of the People Act. The question as to whether the proposals put forward in this purported exercise of its constitutional function by the Election and Boundaries Constitution, that has never come before any law, any court. it is a new matter. So this idea or this application to declare them or to strike them out because they are sub judice cartel, they have been heard and dealt with by the court before, is clearly nonsensical.
Notably, prior to March 12 general election, Prime Minister John Briceño committed to seeing the redistricting exercise completed within the next 2 years. A few days after the election, he doubled down on his initial commitment.
I said that before the end of 2026, but I suspect I'm giving myself to the end of 2026, but I will aim for 2025, by the end of 2025.
Based on these remarks, Guerra says the ongoing claim is moot.
So really this entire case is moot because the constitutionally envisioned process is now in motion. My instructions are that the Elections and Boundaries Commission is fully prepared and is on standby, ready, willing and able to carry out whatever duties they're required to do under the Constitution.
Reporting for News 5.
People at home and abroad, and gentlemen,
They should have
I
done that
want to
already,
say
not
this.
not on standby. They shouldn't be on no standby. It should have been done already. They committed to the court and they lied to the court and said to the court,
People at home and abroad, Mr. Brackett, I want to say this. They got caught. They know they did an illegal election. That is why at the end they are saying election and boundaries is on standby, and the Prime Minister is saying he will do it in a year. But I'm saying that to say why res judicata and estoppel cannot be used in this case. You cannot have a consent order, an agreement, and the case is dismissed on that, and you want to use that to bar any other individual to refile on you, because a consent order agreement is not a judgment on the merits. The underlying merits is the Constitution. Were you in alignment with the Constitution? And you are telling on yourself you were not. And to set the record straight, before I go to you gentlemen, listen to it.
5. Dismissed. Dismissal occurs when a court formally ends a case without reaching a judgment on its merits. Cases can be dismissed for various reasons, such as lack of evidence, procedural errors, or settlements. When a case is dismissed, it essentially means that the legal action is terminated without a decision on the underlying issues. In summary, these terms differ in their legal implications. Injunction is a court order to either do or refrain from doing something. Stay is a temporary suspension of legal proceedings. Suspended implies a temporary hold or cessation of an action or right. Disposed means that a legal matter has reached a conclusion or has been resolved. Dismissed signifies the formal termination of a case without a judgment on its merits.
Gentlemen, what is the merits of this case? The Constitution, Section 90, and the alignment that the government should have done with it before they had the general election. I go to you first, Mr. Morrison.
Oh, sorry.
Yes. Good evening again. We were talking about terms and different type of issues under our Constitution. For example, under our Constitution, we have equal and separate branches of government, and we talked about those briefly. The legislative, which is the National Assembly, which is made up of the House of Representatives and the Senate, the judiciary, which is our courts or Supreme Court and all our magistrate courts and other courts, and then the executive, which is our cabinet and our prime minister and also our governor general. But what I have seen is that under the principles of staris decisis or estapo, or any of those terms, we are making some grave danger as we try to develop our constitutional democracy. Mr. Errington had it so right when he said that, in fact, the role and the responsibility of being our chief legal protector of our Constitution and our rights as people was our Attorney General. But in fact, the Attorney General went just the other direction. He went in support of the government policies. He forgets his primary responsibility and role, even in fact of the government that appoints him to that
People of
position.
Belize.
He is not obligated to follow the wishes and desires of the government. What he's responsible for is to follow the laws and constitution of the country. And he failed in that principle. And so what that has done, it has put in danger our constitution, our rights of every citizen, and in fact, the entire democracy of our country. And we keep doing this over and over. And this is not the first administration to have so breached our laws and the Constitution. It has been done by PUP, it has been done by UDP. And we need to have these people act lawfully and act with the interests of our country and our nation and not their political specific interests, because it endangers all of us as we move forward in trying to build a democracy.
Well stipulated, Mr. Morrison.
Thank you, Mr. Morrison. I go to you, Mr. Brackett.
Thank you very much again, sir, for the opportunity to add some additional comments. As I said earlier, well, okay, let me stay focused on, as I said earlier, in order for there to be an estoppel, in order for there to be a bar, in order for there to be a block, or any opportunity to stop the claimants from, as they are trying to say, take two bites at the same apple, which is not what the truth is. They are lying through their teeth. And that young man that was talking on behalf of the Attorney General, he was lying through his teeth, and he's saying things that doesn't comport to the facts. Of course, they have a right to say what they want to say. They are lawyers. As a matter of fact, from my vantage point, I have always believed that lawyers are liars on behalf of their client. Whatever it takes for their client to succeed, that's their job. But there are rules, regulations, there are process, procedures, protocols that are required of these lawyers. That's why when they become a member of the bar, they can be sanctioned for being contemptuous of the court and of the system. Because when they go and they talk and say crap to the judge that it does not comport to the facts, that means that they're doing what you call a misrepresentation of facts. They can be hauled into jail for that kind of conduct. They can lose their license to practice. But who is going to grab any of these individuals right now that are misbehaving in that fashion right now? Very few people would even speak up about the issue. So when Mr. Courtney gets up there,
let me ask you a question. Let me ask a
and
question.
lies.
Let me ask a question. Has the court made a ruling as to whether they are going to of how they will rule on this case? Has
There are
anything
indications, but there's no ruling yet. It's been held in reserve.
Okay.
Sometime at the end of this week, I think the
Okay.
hard
Okay.
copy should
So
come out.
we can't step ahead of ourselves as to whether the court will self-correct. Because if we look at the way it's framed right now, and the presentation, that's one thing. But we have to make sure that there are not signs of cracks within our judicial system and our courts.
That is what I'm referring to when I say that we are looking at their track records. And the same judge with the same, the first thing that they asked when Miss Pitts made her original submission on behalf of Mr. Wade, in this case, that is right now going to be, that just got heard Monday and will be ruled on, or at least the ruling will be brought out probably by Friday or sometime next week. The first question the judge asked Miss Pitts, is this not an estoppel? Is this not res judicata? Because those matters had been discussed with the Attorney General's office, who supports with the Crown Councils who work both for the Attorney General's office as well as for the court. So those matters are issues that they discuss among themselves, and therefore that's the reason why they asked her the first question in that way. Why? Because they wanted to tell her, you're bringing a case that has already been adjudged, has already been ruled on, when in fact all legal trained minds in Belize, even those who are not participating in this process right now, are aware that that is not the case.
Yeah. Well, I'm hoping the court does not make that error, because I think everyone can see that that particular matter of whether the
Mr. Morrison, if
yes,
you
sir.
saw the presentation, I had hoped that you guys will quite understand what is happening. When you dismiss a case based on a consent order and agreement, that is not a final judgment on the merits. The merits of the case is the alignment from the Election and Boundaries Commission with Section 90 of the Constitution. There is no judgment.
When the judge made that ruling in that fashion and provided 41 pages to back up what she was implying, Judge Neby, she was putting the claimants of that particular case in a bad situation, because they knew that the claimants were not money people that could afford to go.
Brackett.
Wait. That could afford to go and get that ruling overturned at an appellate level. There is the possibility that now this particular issue, if it's not dealt well or correctly, according to law, may end up at the appellate level. But that's the kind of game that they play. They block you off and they put up obstacles for you to overcome. And if you can't overcome them, then it's a very decisive case as far as they are concerned. You cannot overcome.
Mr. Brackett, and Mr. Brackett, what I'm trying to get at is, at this point, the court has not made a ruling
on this particular case, but they are made on previous case.
The lawyers for the plaintiff has made his presentation. His presentation seemed to be filled with a lot of errors in terms of law. And I'm not a lawyer, but it seems to be filled with a lot of errors in terms of law, because he's claiming it to be estoppel.
Mr. Chairman, can I add one sentence again in the context of what we are discussing right now? The first thing that the process of how the courts work is that if you are an aggrieved person, you take out a suit or case against whoever you're aggrieved or who done you whatever harm. When that matter is pulled up in the court docket, and you have to go to the court in the first instance to discuss and figure out whether or not the matter has any judicial value, or it's a case that should go forward.
Mr. Brackett.
Wait, don't cut me off. I know to get to the point.
Well, go ahead, Leonard. Go ahead.
Then the issue is that in those cases, the judge is going to say, okay, well, you know what? This case doesn't really have merits. therefore, they can't go forward. It doesn't have any legs to stand on or to run on, in other words. It's not meeting the requirements of how the legal system is structured and the requirements of the system. But if the case has merits, as the previous CJ had said, two previous CJ had said that the case had merit, then you have to give the case a hearing. So now, when they go out, in the case of this particular instance with Mr. Wade, when the case was brought up by Ms. Pitts, the lawyer, they wanted to have the case thrown out right there and then. Okay? But they could not. Why? Because there was no res judicata. So then the case followed forward, and at the end of the day, they're still arguing the same thing. In other words, they did not respond to the claimant's submittal. When the claimant submit the case formally, the respondents have, by law and by procedural practices in the court, have to respond to the claimant's demand for redress. And this, the government lawyers, as of today date, had only mentioned about 2 of the items throughout the whole of these proceedings that the claimants were claiming. And they dismissed the whole rest of it and don't want to talk about it. They don't want to deal with it. And they provided a whole lot of other stuff.
Can I ask you a question?
Yes, sir.
Because you're beating up yourself. And I have always stated, I only deal and facts.
And we're here
I
trying to
only
explain to people.
deal and facts. The question is,
Well, if they deal on facts,
was
only,
there
why
a
are we here?
judgment,
Why are
sir?
we even having this discussion?
Can you answer the question for me or anyone out there? Was
There's
there
no
a judgment in this
There's
case?
no judgment. There's no judgment. There was no judgment in this case at this point.
Thank you, Mr. Morrison.
And that's what we're waiting
Then,
for.
if there is no judgment, there is no res judicata, there is no estoppel.
That's why you have to explain, Greg, because based on what you are saying just now, is incorrect. People will be misled and misinformed.
People cannot be
leave it like that.
misled.
You have to explain it, which is what you're telling me that I shouldn't waste my time explaining it, because you know what we are talking about. The people that we are catering to
help us better understand,
how it works, how the pieces
to
fit
help
so that
us
they can-
better understand, before I go to you, Mr. Wade, let's hear it from the tape.
In this video, we will discuss claim preclusion. As a practical matter, claim preclusion prevents parties from suing each other over and over again after a case ends. In other words, when a civil litigation is over, it's over. For example, let's say we have Patty, who's happily driving her car. David comes by on his truck. Unfortunately, he's distracted talking on his phone, and David crashes into Patty's car. So Patty sues David for negligence, and we'll say she's claiming at least $500,000 in damages. The jury agrees that David was negligent, but only awards Patty $100,000. Patty's upset. She wanted a larger damages award. Then Patty gets an idea. Why don't I sue David again? She could sue David in a different court, with a different judge, a different jury. And come to think of it, America's a big country. Why not sue David in a different state for the remaining $400,000? And remember, in the first case, Patty only sued David for negligence. In a second case, why not allege that David intentionally hit her with his truck? The doctrine of claim preclusion tells us that Patty probably can't sue David again. Claim preclusion generally prohibits the same parties from suing each other again based on the same underlying incident. In our example, we have the same plaintiff trying to sue the same defendant again. And the second lawsuit is based on the same underlying event, the accident between Patty and David. Because a jury reached its verdict in the first case, Patty probably can't sue David again based on that car accident. Claim for
So there you go, gentlemen.
Res judicata and estoppel.
There was no judgment. That is why the case is back in court.
Yeah.
And
And
if
I
there
and
is
I
no judgment, there is no res judicata and there is no estoppel.
Exactly.
yeah.
Period. So when the lawyer was speaking about that,
She's talking
he
about
was
turn and
just
complexity.
throwing a narrative out there
Yes.
to the people of Belize who don't really understand what is happening. Go ahead, Mr. Morrison.
And that's the point. That's the point exactly. And that's why I was concerned to find out what the ruling of the court is, because we cannot make presumption at this point what the ruling of the court is, because they understand these legal issues fully more than you and I does. We're not lawyers. And so based on that, I'm waiting for a ruling from the court to determine where they stand and if they're standing to continue with this case as it is. And the election has passed. It may have been an illegal election based on or unconstitutional election, and we don't know what the remedy is for that after an election. And particularly since the court
Mr.
had
Morrison,
kind of not dealt with it.
Mr. Morrison, you are 100% right. That is why the good young lawyer is trying to show compliance to the public and the world by saying the Election and Boundaries Commission is ready to perform now, and the Prime Minister has said he will do it in a year. That is telling on yourself. You were not in compliance with the Constitution, and that is why you have no res judicata or no estoppel. So let's stop playing the game, man. Mr. Wade, let me go to Mr. Wade first.
I'll only say this, that the whole thing is that they presented that I am one of the previous claimant. That's the narrative that they put to the judge. And they centered that the whole case, including my case, this last 7:30 of 2024, around that, which in fact they lied because I was not part of, and that's in my one of my affidavit. But that's the perception that they put out there to the judge. Rudy Wade, part and parcel of 2019, which is a lie, right? And that's the reason why, because the judge already, 2019 has already ruled on, which is a lie, right? In our sense, and they refuse to address the constitutionality of 7:30 of 2024. They don't want to address that because right there they are wrong, 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 as per our constitution, not my constitution, the law of the land. But they're wiping that off the table. That's not the force with those guys, right? So I only say is that, we'll wait and see what the judge will rule on. All I can say, it's not a done deal. That's all I
Thank you,
can
Mr.
say.
Wade. Mr. Brackett.
Yes, sir. Well said, Mr. Wade. And very factual and pointed today, as specifically regards to how the respondents respond throughout the whole of this process from beginning to end. by just playing a shell game, bamboozling, conflating, misdirecting, and filing bogus response that had nothing to do with the original claim. They
They
refused
also
to
said,
address.
to let me interject this
Go
too,
ahead, go
because
ahead,
public
go ahead, sir.
knowledge. They
Go ahead.
also said that what the last party are doing, they are using me. They are fronting me to put through the same agenda, right? So I am just a front, right? And the case should rest because it was dealt with before. And
Mr. Wade,
linking me again, right? Part and parcel
can I
of
clear that part up?
2019.
Can I clear that part up?
Again, it's a lie.
Okay.
Right.
When they're making those kind of motions and making that kind of statements, what they're doing is that they're misinforming, they're misapplying the rule, they're not playing fair. Then they're turning around and saying that you had heard and known about the previous case, so therefore, by you having heard and known about the previous case, that you are blocked from being able to bring your own case. They fail
They're
to
not
remember.
asking me, Leonard and
Wait,
guys. They're
wait.
telling the court. They are
Yeah.
in my mind. They know
Yes,
what
but
I was thinking, and then they are thinking for me. Did not give me a
they're
chance
not
to
just
say, well,
thinking for
like,
you,
these
they're
guys
trying to
are
position,
lying,
Mr. Wade,
right? Did
they're
not
not
give
just
me a
thinking for
chance.
you, sir. They're trying to position you, the way they describe you, to the court, for the court to be able to believe what they're saying has merits, when in fact it has no merits. They're just bamboozling. They're not responding to what you're claiming in the first place. They don't want to relate to that. They don't want to answer to that because they don't have a leg to stand on when it comes to the violation of the Constitution. So they go around in circles and try to address all these extraneous issues that has no merits and waste the court time and your time, and they are getting handsomely paid to go through that kind of shenanigan game. But at the end of the day, if the judge was to rule according to the requirements of the system, that is, to rule according to law, because it's not just a plain, it's just not a plain civil case or a tort case. It's a constitutional case. The Constitution has to be measured and given life. That is the responsibility, according to the Constitution, Section 95, that empowers the judges and requires the judges to use that power that they're empowered with to render justice.
Also,
And they
one
have
more
to
item,
render
guys.
justice according to law. This is why
They said to the
some
court
judges get their case
publicly
overturned on appeal.
that Roody Wade, should not be doing what he's doing because I participated in the election.
All the more you
Although
have a right.
I am saying that the election is illegal, like they're trying to say, well, he participated anyway, so why is he here?
All the more you have
That's
standing.
the extent they went to, right? Disregarding my constitutional right as a Belizean, as a voter, right? Born Belizean, they disregard that.
And
Right?
as a candidate.
And as a candidate. And I shouldn't be there because I participated. How shallow,
According to our system and of governance and according to our constitution, every individual Belizean is equal under the law and is entitled to not be discriminated against, as well as for any other one person, for himself, or any other person that person think was done a wrong to. Okay? That's what the Constitution says. So when they come with their shenanigans, they tell you crap, or they say the type of nonsense, when they say out there, as lawyers, they should know that they're lying. They're conflating. They're misrepresenting. But they're getting paid to go out there and run the story to make it sound good on their side, while they're the ones who are committing the crimes under the color of law. I yield back.
Back to you, Greg. Back to you, Greg.
Thank you, guys.
All about money.
Mr. Morrison?
I kind of wonder where we go with this. We do need to look at where kind of wait for the court ruling to see where the court stands on it. But definitely, it seems to me, from whatever little understanding I have of the law, is that this does not meet stare decisis or estoppel or any of those other legal terms that would disqualify it as a valid case to be heard by the court. And so I'm wondering how we move forward before we get a court ruling. I think right now we just got to wait for the court ruling, and then we could kind of see whether the court itself has been strained in political ways that voids that separation of government that we talk about, where the legislative is supposed to be equal and independent of the executive. And so those are the concerns I have. And so right now I just put everything on hold in my mind, and I'm waiting for a court decision and to see how this will play out. Because if it was to rule and accept the stare decisis or estoppel principles of previously being heard, then we have some serious flaws and cracks that are real within our democratic framework of system of governance, and that should be troubling to every single citizen, Belizean, whether they're in Belize or whether they sit and live outside of the country.
Mr. Brackett?
Yes, sir. Thank you. I'll just read a little piece of a essay that I put together. I'm not going to read the whole because we don't have enough time for tonight. It's actually set up for Friday night, but just to preface and to lend a little bit of the support in terms of the Constitution speaking for itself. I'll just read a little part of this because it's good for us to banter these things around, but when it comes to the Constitution and the law itself, which is the supreme law of the land, we should take heed. The following commentary was made by Leonard Brackett regarding government of Belize unconstitutional and violation of scofflaws conduct. Belize Constitution violation, Section 90 and ROPA Schedule 1. Inconsistencies, etc., etc. That is a teachable moment, is what this essay is going to be about. But I'm just going to read a little, one paragraph from it, and I'm not going to read no more of it, just the one paragraph. And this one paragraph includes the summation of some of the sections of the Constitution that are germane to the whole of this discussion we're having here tonight, and the case itself submitted previously, and the case itself submitted in the second instance with Mr. Wade, and the attempt for these jackals to try and conflate the fact that because tumbling agreement, side agreement, was ruled on to try and conflate that ruling constitute a ruling onto the whole case itself. The judge herself, Judge Naby, said that she wasn't ruling on the original case. She was ruling in regards to the request that was made of her to sanction the government for its non-compliance. And as far as she was concerned, the government, Election and Boundary, had complied by doing a sleight of hand and submitted that sleight of hand, which did not comply with the requirements of the Constitution. And then the House refused to vote on it because they didn't consider it to have been done correctly. But they were the one who engineered it getting done by the Election and Boundaries through the appointed political officers in the commission. The commission is made up of 5 different individuals. 3 from the POP and 2 from UDP. And the 3 from the UDP carried the day in terms of doing it the way they did it and then presenting it to the House the way they presented it, knowing that it was destined for non-acceptance. It was all a shenanigan and a sham from the get-go. We have no historically those facts to back up, such a statement. Previously, when it was being said, we will have the same question like Mr. Morrison have right now. The judge has not spoken to the issue in terms of a final written judgment. And while that is true, we also have the previous cases before on which they are trying to make this judgment contingent, and they are the respondents did not respond to the original case. I mean, when I say the original case, I mean the case that Mr. Wade then filed. The respondent refused to entertain any discussion or hearing of Mr. Wade's complaint. And when they realized that they couldn't get over it, they started attacking him as being unfit and or incapable of being able to have a case submitted under his own grievance. The bottom line is that these guys are a bunch of jackals. They don't want to do nothing that is correct or right. They're going to lie through their teeth, and they're going to fabricate stuff and bamboozle and mislead the court, and they all deserve to go to jail for contempt of court. But who's going to tell them, who's going to arrest them and send them to jail for contempt of court when they're representing the government, who decides who gets prosecuted or not? Let me read the thing. It's not a lot of stuff. It's just one little short thing about... Okay, let me read it and stop and talk about it. These are some citations from the Belize Constitution, right? Starting at Part 1, Section 1, and Section 2, Subsection 1, as well as Part 2, Section 6, Subsection 1, and Section 16, Subsection 1, and Subsection 2, and Section 20, Subsection 1, and Subsection 2, and 3, all the way through Subsection 8, as well as Part 6, Section 88, and Section 89, and Section 90, and Section 91, and Part 95. Now, all those various sections of the Constitution that were cited there constitute what you say like a fence or a corral around these jackals that are trying to bamboozle their way through this process and this particular case. Had this case been submitted under these specific constitutional citation, the Constitution will be speaking for itself, and they will be arguing against the Constitution rather than trying to play games and pretend that they are such high-powered lawyers to talk down to any other lawyers that are not on their level. The Constitution can speak for itself, it's self-preserving, and it can defend itself when given a voice. All you got to do is give it a voice. I yield back, Mr. Chairman.
Thank you, Mr. Brackett. Mr. Wade, you want to say something?
No, go ahead, Greg, because we...
Gentlemen and people at home and abroad, to further enlighten you on the difference between res judicata and estoppel, so that you can more understand, I will play the tape.
Which means there is a prior lawsuit that's going to affect a current lawsuit. A prior lawsuit that's going to affect a current lawsuit. So preclusion analysis, whether it's claim or issue, is going to require you to look at the prior lawsuit and the current lawsuit and compare them to an extent. All right, so what are you comparing? Well, the first thing you're comparing are the parties. So claim preclusion, for it to apply, requires the current lawsuit to involve the same parties situated as they were in the first lawsuit, meaning situated on the same side of the V. Plaintiff versus defendant in the first lawsuit, and that same plaintiff has taken the plaintiff's position again in the second lawsuit. So it's not just the same parties, but the same parties positioned in the same way in the second lawsuit. All right, so we're comparing these lawsuits. Next, you want to make sure that the second lawsuit arises from the same transaction or occurrence as the first lawsuit. So if the first lawsuit was about a car accident, is this second lawsuit about a car accident as well? Or, excuse me, that same car accident, not just any car accident, but that same car accident? So you've got the same plaintiff and defendant positioned in the same way. You've got the same transaction or occurrence, that car accident. You've got one more thing you've got to find: a valid final judgment on the merits. That's a big, long phrase, but it's not that complicated. Valid final judgment just means you have a final judgment. The case is done. Validity is an important word, but it deals with jurisdiction, and it's rarely absent in a situation like this. Final judgment means the case is done and on the merits. What does it mean to be on the merits? The best way to remember on the merits is to remember those few situations, 3 total, in which something is not on the merits. When does a case end in a non-merits adjudication? It ends when there is a dismissal for lack of subject matter jurisdiction, personal jurisdiction, or venue. If the case is dismissed because the court lacks subject matter jurisdiction, personal jurisdiction, or venue, that dismissal is not on the merits. Not on the merits. Any other dismissal, summary judgment, you lose at trial, motion to dismiss, a default judgment, those are all on the merits. So we look at that first lawsuit. We say, did that involve the same parties situated in the same way as the current lawsuit? Did that first lawsuit involve the same transaction or occurrence as at issue in this lawsuit? And did that first lawsuit end in a valid final judgment on the merits? If it did, sorry, you can't relive.
There you go, gentlemen, and people at home and abroad.
The question then is, did it?
If there was a judgment, this case would not even be where it's at today. So we know there was no judgment. I brought this presentation tonight so that you, the people at home and abroad, could understand the meaning of res judicata and estoppel, and what bars a plaintiff to refile a motion, when it can be filed and when it cannot be filed. There is no bar to refile a motion if there is no judgment on the merit. And in this redistricting case, there was no judgment on the merit. There was a consent agreement, and that was all, a dismissal for a consent agreement. Mr. Brackett.
One other point as well, and that is that the case was the case that they're claiming was ruled on did not happen, did not get a hearing. The case that they don't want to answer to right now, as of today's date, did not get a hearing as well, because the substance of what transpired in the courtroom on Monday was all about having to prove whether or not there's any estoppel or any res judicata. That's what the whole other thing was all about. Okay? It did not have where the respondents were responding to the allegations made against them. They refused to entertain that. And they tried to carry the case into a different cubby hole that they were prepared to defend, that had no issue attached to it in terms of they having a leg to stand on constitutionally, because they did not. They themselves declared that they were in violation of the Constitution.
Well, I think they didn't want to admit they had an unconstitutional election, Mr. Brackett.
Well,
You're correct, Mr. Morrison.
Right on the money there, Mr. Morrison.
You're 100+% correct, because you know what it's about.
Yes,
It's a test for a constitution, and I am waiting for the outcome, because we know, we that study law and look at law, we know it is not a bar to refile, and we know for a fact that the government compliance was not aligned with the Constitution. because, like I always say, they always telling themselves they were saying it even before they went to the House and voted it
Greg,
out.
let me point out where they were telling on themselves. For example, while Mr. Courtney had been spending time in front of the judge, conflating and lying to the judge initially during the same Christmas season, he was sitting down with the Prime Minister, as the Prime Minister said in his own words, with Mr. Courtney and his other advisors, strategizing as to how they want to bullyrag the process to make them end up, they have their election, and they had already decided on the 13th date on the Christmas night. Did they tell on themselves?
The important thing here, Mr. Brackett, is our Constitution is being put to test. If this judge ruled in the favor of the plaintiff, it's sad to say that the ruling makes the election illegal and unconstitutional. And it would also prove that when the case was dismissed based on the consent agreement, because they said they were in compliance, they were not in
The
compliance,
judge erred.
okay?
He took a
And that
promise.
means,
He took a promise and depended on that promise that still has not been fulfilled as of today. Yet we're having this discussion.
but gentlemen, we are close to that time, Mr. Morrison. Before I go to Mr. Wade, let me hear you.
Well, as I said, I await the ruling of the judge on this case. But then we are pressed to imagine what would be the remedy if this was in fact if in fact we get a ruling that the constitution of the country was violated and the election was illegal. That would be
Mr. Morrison, you know what is at stake here? The government can be sanctioned for violating a consent agreement when
yeah,
they
but what's
said
the
they
remedy?
were in
But what's the
compliance,
remedy?
when
But
they
what's the
stated they
remedy?
were in compliance.
I
That is
understand,
what
but
is at stake. That
I
is
understand
why
that.
the young
But the
attorney,
remedy, Mr. Wade, Mr. Brackett, the remedy is the issue under this type of violation. What would be the remedy?
The correct
How would
remedy
that?
is to declare the election that they were fighting and trying to bamboozle everything about as being null and void and not being constitutional. But that will not happen.
Well, that's what I'm saying. That's what I'm saying. How do
That is the
you
proper remedy.
remedy this after this point? After all this have happened, how do you remedy this?
Our system is not strong enough. Our system is not strong enough to
Yeah,
bring
yeah.
about
That's
that.
my
gentlemen,
concern. That's my
the
concern.
truth is in the pudding, as we always say. We know what happened, we can see what happened, and that is why the young attorney is trying to say the case is moot, because they know they messed up, big time messed up.
He's just
And you know what he's trying to
he's
use?
just a messenger, and he's been
You
educated.
see what they are trying to use?
But
Because the election and boundaries is ready to go, and the Prime Minister say within a year the case is moot. No, it is not. Because you were not in compliance. You were not in compliance.
yeah, no,
And
but
you get
Mr.
by.
Mr. Wade, Mr. Brackett, I'm sorry. The issue is that if the remedy is to call elections, to call a new election, then that's where we are.
Yeah, but
You
our
see what I'm
system
saying?
is
But we don't know. We don't know yet where the judge will rule. But it
the judge.
seems to me that if it was unconstitutional, we have no other legal process than to make an election constitutional, and that would be to call a new election within a period of time after they have completed a legal redistricting, not redistricting, because we have yes, redistricting, to satisfy the requirements of the Constitution.
Mr. Morrison, to help you there, Mr. Morrison, The election could have called on the 25th of November more than adequate time to do the redistricting. So we know they are not in compliance. And they know that we know it was an illegal election because you didn't have to rush it. So we know.
Anyway, guys,
Mr. Wade, I go to you for your comment and
thank
the
you.
closing.
It's always a pleasure, good discussion of real things, of real, what had happened, and what continue to happen. And I just hope that the people, both at home and abroad, would see the system for what it is and what they are doing to our Belizean people, right? On that note, Mr. Morrison, I want to thank you for joining us tonight. And to our viewers and listeners, both at home and abroad, and those who will view us a little later, I want to thank you for that energy. And please share. And I invite all Belizeans, both at home and abroad, to voice your concern concerning the same issue, because it's a pressing issue and it's a necessary event that needs to be had so that the people in Belize have equal or near as equal representation. As of now, it's not happening. So if we want to keep kicking the ball down the road, that's fine, but that's illegal. So why not just get it done and do the right thing by the people and nation? And that's all we're asking. And you know, Greg, it's a pleasure to always have you, my brother, to show and tell, to cue up these things and show the nation, right? That not only we decide, it comes from them, our leaders, the system, right? So is it right? No, it's not right. It's all wrong, 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 wrong. And Leonard, it's a pleasure to always sit with you, my brother.
You're welcome, sir.
Thank you.
Thank you,
They
Mr.
say
Wade.
it's not three the hard way, it's four the hard way, right here.
For,
We
Thank you,
speak,
Mr.
we
Wade.
speak from the heart. Thank you, thank you, guys.
I want to take 10 seconds for my closing. 1, 2, 3. I owe each of you gentlemen at least a penny because I'm betting you, even though you're not putting up a bet or you're not accepting as a bet, but I'm declaring a bet that if the judgment comes out saying that the government was at fault and the election has to be redone, it will never ever happen. That race has already, the horses were out and the race was run. They already given all the cups for the winners and everything.
Yeah.
And if the judge rules contrary to that, then I owe each of you gentlemen at least a penny each. Thank you very much for your great contribution to tonight's program. This is one for the archives.
Thank you.
Thank you, Mr. Brackett. With that said, good night to you, the people at home and abroad. We thank you for tuning into this, our 278th episode of Belizean Affairs.
Nice
Mr.
program.
Morrison, it is always a pleasure to have you on the virtual platform. With that, I say good night.
Thank you. And